Hello everyone and welcome to today's Mondac webinar in association with Olivares, who will be discussing copyright considerations in Mexico. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Louis Schmidt joined Olivares in 1991, becoming a partner in 1995 and has almost 40 years of legal experience with a specialization in copyright in the business of entertainment and culture. He has represented the world's leading companies in the music, film, television, book publishing, fine arts, design, folklore, and software. Jamie Rodriguez joined Olivares in 2007 and became a partner in 2023. He has extensive experience in copyright, litigation, trademarks, unfair competition, and domain name dispute resolution, and this versatility has allowed him to participate in a variety of relevant matters in cases pertaining to different areas of intellectual property. Riccio Yanis joined Olivares in 2011. He initially worked for 2 years with the litigation team. In 2014, he became part of the copyright and media, sports and entertainment law teams. He advises clients on drafting and negotiation of contracts related to the entertainment industry. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavour to answer as many of those questions as possible. But for now, it's my pleasure to hand you over to Luis, Jamie, and Riccio to begin. Thank you.
Hello, thank you. It's very nice being here today. Thank you for participating. Thank you very much, Dan and Mondac. Thank you very much, Elise and Firm Forward. So we're very happy to participate and convey some thoughts about copyrights and related matters as they are happening in Mexico. Mexico is a good place where to analyze copyrights because industries, especially all those related with audiovisual production and distribution, music, arts in general, they are important. They are perhaps the most important market for that in Latin America, and I would say in some other parts of the world as well. Important companies, especially platforms, especially and the producers and financiers are betting in Mexico and have been for many years. Like the Mexican hub of Netflix, Amazon, HBO, VIX, Apple, and Disney are quite important in Mexico. The presence of Warner Brothers and the studios is very important as well. And Spotify, Mexico is one of the leading countries, and some other industries that are related to that as well. So we are happy to talk about issues and coming straight to the points. We will start with discussions about music, then a little about audiovisual productions, both on the legal side, but also on the business side, business and legal side. No? So here's our two specialists. They're young people in this firm that are really taking over and picking up and become the new voices of Mexico in connection with all these matters. And Jaime is a little bit more leaned into the legal, Mauricio a little bit more into the business, but they can also intermix and talk about the topics of the other perfectly. Well, we'll start with music, and for that I'll ask Jaime to talk a little bit about this challenges in the industry of music, and talk about a little bit about the conflicts that have been happening and have been resolved by the different courts, especially by the Supreme Court of Mexico. Um, the environment is, surrounding the digital media and behaviors like cyber squatting, BitTorrent, stream ripping, blocking measures, notice and takedowns. So we would like to hear a little bit for a few minutes, Jaime, what you have to convey to us related to all these topics and issues. Please.
Yes, of course, Luis. Thank you to all. It's a pleasure to be here with you. And as you are mentioning, Luis, certainly internet has significantly modified the traditional way of infringing copyrights, and the digital environment has become a common and frequent way to violate copyright. The following activities could be considered in the field of the music industry, such as cyberlocking, on which third-party services allow users to upload, store, and share music files, as well as stream ripping, understood as the process of converting audio files attached to music videos offered on streaming services into permanent audio downloads. And BitTorrent, of course, BitTorrent sites using the peer-to-peer technology to file sharing without the need to rely upon files being hosted by the site providing an index of torrent files. And of course, the Mexican copyright law has adopted the provisions contained in the WCT and the WPPT, as well as other bilateral or trilateral treaties, such as the USMCA, and has incorporated and regulated efficient ways to combat this type of illegal practices. One of these mechanisms is the incorporation into the Mexican copyright law of a notice and takedown procedure, which is quite similar to the one regulated or provided by the DMCA or the European directive in connection with the digital services in the market. However, it is important to mention that these provisions related to notice and takedown procedures, which were incorporated into the Mexican copyright law, has been challenged by the Human Rights Commission through the filing of an unconstitutionality action, and the Supreme Court of Justice has not solved this action yet. It is worth mentioning that this notice and takedown procedure, including the corresponding safe harbors, which also are very similar to the ones contained in the DMCA and in the European directive, has a significant impact only in connection with Mexican companies or companies that are domiciled in Mexico. For those cases on which there is an infringing content or material provided by intermediaries, of course, the provisions contained in the DMCA and the European directive, depending if the legal entities are based in Europe or in the US, can be applied in Mexico. As well, it is important to mention that the Mexican legal framework has adopted and recognized specific preliminary injunctions for the digital environment, allowing the corresponding authorities to order infringing parties and intermediaries to suspend, block, and remove infringing content of course, and also order the cease of the infringing activities. In connection with this point, it is worth mentioning that in Mexico, ISPs, internet service providers, have been reluctant to comply with these injunction orders ordered by INPI or by any other judicial authority. And in Mexico, we have an important, a landmark case, which is the so-called Alestra case, which was derived from an administrative action filed by record labeling companies before INPI, which is the Mexican Institute of Industrial Property, against a cyberlocker hosting a website related to cyberlocking activities, mymusic.com. And in this case, INPI ordered an injunction to several ISPs, and one of them, which was Alestra, filed an amparo action against this injunction order implemented by the Mexican Patent and Trademark Office. And in the end, this case was solved by the Supreme Court of Justice, settling the basis to solve these conflicts between copyright as a human right against other human rights, which could be the access to information and freedom of expression. The court concluded that blocking to access must not be total, but must be partial. Only blocking access to the infringing materials, unless that the majority or totality of the website, it should be considered as infringing. This is a little bit problematic, and as a consequence, additional alternatives had been tested or implemented, which could be dynamic injunctions. And in Mexico, there is a case, it is confidential, but we can only mention that it is related to broadcasting companies in connection with sporting events, specifically related to football matches. And in these cases, the Mexican Patent and Trademark Office allowed to implement some specific injunctions restricted in time to certain dates only through a couple of months during Saturdays and Sundays, which were the dates which the sporting events took place. And this was a mechanism to establish that the injunction orders were not total, but only partial. I don't know, Mauricio, Luis, if you want to add anything else in connection with points.
I would ask Mauricio now to intervene and talk a little bit about everything you have explained, Jaime, in connection with all these challenges and all these disputes and all this litigation on the music side within music industries and in connection with digital environments. To talk a little bit about the effects on the business side, on the pragmatical on the pragmatical platform where all the business runs. No, please let us know something about it, Mauricio.
Of course, thanks everyone to be here. And yeah, it's not new to say that tech disrupts markets, which is the best example is the internet and everything else that came after the internet as a new technology. And all of these platforms that have been created in order to have different ways to access entertainment, culture, information, education, and obviously it increases market opportunities, it increases business opportunities, obviously, as Jaime has already pointed out. it also comes with new challenges, new kind of activities that might infringe rights. And that's why we as lawyers need to be updated about these new activities that are happening among us, that new technology is changing every single day. And we need to understand how this technology works in order to give better advice, either for enforcement of the IP rights, or avoiding infringing third-party IP rights. This is very important to be a good advice for our clients in order to protect their investments or the investment from third parties that might be investing into our client's business. We need to make very clear legal strategies, very clear copyright protection strategies to have all these investments that are being made nowadays done in these different industries: music, audiovisual production, and the new platforms that have opened the markets in an international way that it never happened before, or just in a fewer cases this used to happen. Nowadays is more often to see way more cultural and entertainment products on cross markets among the world. We can now see audiovisual productions and hear music from all over the world just by accessing our phone. This is obviously a tremendous opportunity for making business all over the world, but also it implies challenges that need to be respected. All the markets that you are going to point and all the markets that you are going to attack on this new business model. It's more common to be regulated under the platform rules, under the platform terms and conditions. Most of them are under the US laws, some other under the European laws. And we need to take that into consideration. We need to study them. We need to give good advice. Even if we are not US law experts, we need to be pretty well aware of what is happening on other countries, on legal precedents, in order to make way more complete legal strategies of protection to our clients and to their business models. Investment in entertainment and cultural experiences right now, it's growing and growing and growing, even since the pandemic. Well, I think everyone increased drastically its consumption of audiovisual productions, series, film, TV, because there was not much other things to do. And since that, the new offer of audiovisual products around the world has increased, and hopefully it will stay. And we need to procure that, and we need to procure that by taking care of the investment on the business model and on the monies that regard the production of music, of audiovisual, and everything that involves the entertainment business in general, the new kind of experiences that have been offered, these new interactive experiences, VR experiences, all the new environment of blockchain, metaverse, and it's still happening that we have new tech disruptions of the markets, new business opportunities. Right now, we'll start seeing AI on as part of these business models, as part of this, as a tool to create and as a tool to procure new ways of having products of entertainment, also cultural experiences. And we need to be well aware of from a copyright and from a legal standpoint, what does imply these new activities under the current and the laws we have, the applicable and valid laws we have today. We need to understand these new activities in order to make a legal frame for our clients as a legal strategy to avoid infringing third parties or enforcing their own copyrights.
Very good, Mauricio and Jaime. So let's quickly jump into another topic, which is copyright registration. Please, Jaime, start again and tell us about the protection, the copyright protection implying or not implying copyright registration, whether there's automatic protection, and what's the role of registration in connection with the protection of copyrights in Mexico, and if you can compare a little, just a little, with other systems, especially European, where there's no copyright offices like in Germany, France. Please let us know a little bit about that. And then Mauricio, I will ask you to assert something in connection with again protecting copyrights in projects like audiovisual, especially, and the relation of chain of title. What would you expect if you are a financier, that your producer provides and proves that there's a chain of title, that there's copyright protection for that draft or that project, and you as a financier will then approve funds for that. Please start, Jaime.
Yes, thank you, Luis. Well, regarding copyright protection in Mexico, it is worth mentioning that the Mexican legal framework follows the principles contained in several international treaties regarding copyright protection, of course, including the automatic protection principle, without the need of obtaining any type of registration. Accordingly, works are protected from the moment that they are created and fixed in a tangible medium. However, in Mexico, it is possible to register works with the purpose or aim of obtaining additional grounds of legal certainty. Works are registered before Indautor, which is the Mexican Copyright Office. And it is important to mention that the registration is declarative and it is not constitutive of rights. Accordingly, the registration generates a legal presumption that the information contained in the registration certificate is truthful and accurate, and of course that the holder owns the corresponding copyright. However, said legal presumption could be destroyed if it is proven otherwise. The traditional or now the only way to challenge the validity of a copyright registration certificate is through the filing of a nullity action before the Federal Court of Administrative Affairs within a term of 30 days counted as from the date of having knowledge of the existence of the corresponding copyright registration certificate. Indautor, the Mexican Copyright Office, as an administrative authority, cannot deny the registration unless that there is subject matter that it is excluded from the protection of copyright, such as ideas, the commercial exploitation of ideas, simple formats, etc. But the Copyright Office cannot analyze if a work is original or not. Accordingly, there is this possibility of challenging or destroying this validity or presumption of legality that these registration certificates have in Mexico. As well, I would like to point out a particularity regarding the Mexican legal framework in connection with copyright, which is the validity or duration of copyright protection, as well as in connection with neighboring rights, because this protection is broader than in the rest of the world. Speaking about copyright protection, should be considered that the duration or validity is the life of the author plus 100 years. If we are speaking about neighboring rights, and we are talking about the rights of performers, it is become necessary to explain that the protection is of 75 years counted as from the fixation or from the moment which the performance is publicly available. As well, in connection with book publishers, the protection is granted for 50 years, counted that from the first edition. And in connection with record labeling companies, it is worth mentioning that the protection is granted for 75 years, counted as from the fixation. And broadcasting organizations, the protection is for 50 years. Mauricio.
Okay, Mauricio, that is your turn.
Thank you. Yeah, the copyright protection, as Jaime has already explained, it is applicable in Mexico. The absence of formality, according to the Berne Convention. Nonetheless, it is the most accepted way to prove the rights, to prove ownership on a work, on an artistic or literary work. It is the most common way to credit a chain of title in contracts. Every single contract that involves business around entertainment has as a condition precedent the obligation of proving a chain of title, because obviously nobody is gonna invest anything if there's no rights in it. So it is very important to prove a chain and a correct chain of title over a work before entering into any kind of finance models. This is required either by public or private investors. Public funds also required to prove chain of title in order to apply to some tax rebates, to some tax incentives that might be applicable. We fortunately in Mexico have a few options of public funds to apply to produce cultural and entertainment products, mainly film, theater, arts, and some others. There are some local, some federal type of incentives. Some are linked to tax incentives. Some others are more in a public investing business model, and we need to be advising our clients in the correct chain of title of the development of what they are gonna eventually turn out into a product that is gonna be looking for investment and finally to be offered on the market. So it is quite important since the beginning of a project to start drafting the corresponding agreements between companies, between individuals, between authors. If we are gonna have something made under the figure of a work for hire, if we are going to have assignment of rights, all of those need to be obviously according to the applicable law in order to be valid, and those need to be pretty well drafted and procured during these development stages in order to have a solid chain of title once we're gonna try to acquire investment or applying to any public funds or any tax incentives. And the most common form of proving this chain of title, besides having agreements, is that we file those agreements before the Mexican Copyright Office and also obtaining copyright certificates. Although they don't constitute any rights, they are so far, if not the best, at least one of the best ways to prove that you are the right holder of some work. So yeah, there are some other ways that we can prove that we are the right holders over a work. Registration is not necessary, and there might be some other options. Postal service sending via mail our literary work that will prove time, dates, place, in order to prove that the date of creation and some other things that might be useful in case there's a conflict or any litigation regarding that particular work. Nevertheless, on the legal frame and the litigation practice in Mexico, there's a judges tend to ask for registration, and it's something that should not be happening. Nonetheless, it happens, and judges give copyright registrations the validity of a certificate that might constitute rights. Even by law and under international treaties, they do not, at least in Mexico. The criteria from judges on Mexico is to allow the certificate, the copyright registration, as the best way to prove the right holder is correct and in place, and to credit a valid right over a work.
And Mauricio, also, it is a common practice to rely upon the existence of copyright registration certificates issued abroad, right?
Yeah, it also happens since there are some countries that does not have a copyright registration. It's common that either they go to file a registration in Mexico, or they try to. The thing about proving that you are the right holder of a work is that you need something that at least states a date and the title of the work and the name of the author. If you are the author and right holder, then it's easier. If the right holder it's different from the author, then we also need agreements. But there are some cases that you could go to other copyright offices. For instance, the U.S. Copyright Office. You might there are some people that file for a U.S. copyright registration. Also, there can be some certificates that are filed before or that are issued by some
Guilds.
managing organizations and different entities. The thing is to state a proof of the date, the name of the author, and the title of the work.
And identify the work, no? That's important. No?
Yeah,
there's a connection between all this information and the work that is being claimed as protected. No?
exactly. In certificates and in contracts, it's very important to have always, in any kind of contract, the object has to be clear. And in case of agreements surrounding copyrights and works, the work needs to be specified and that it needs to be identifiable.
So great. I think you have provided nice information now, and the audience can understand better regarding all this issues in connection with copyright registration. If there's questions, of course, we will answer that, and we want to leave a little bit space for that purpose. For the time being, we'll jump into the third topic, which is something that relates closely to audiovisual production. And it's a sensitive issue, has become tremendously important in that industries, and is regards the defenses and conflicts and actions deriving from identity of persons. I like to use the word identity, but there's some other people, or I think there's a general statement to call that portrait image, self-image, and these related concepts. In that, put in a balance with all this human rights, which is free speech. That's a challenge, and we would like to hear Jaime to speak about it. How you work on the legal side in order to create protection for images, and on the other side, allow producers to, in certain circumstances, use images of people, sometimes without asking for permission, because you consider you don't need to. Explain us a little bit about all that, and then I will ask Mauricio to assert that on the clearance side. Every audiovisual production requires an analysis that is then annotated in a clearance report, and that's going to be approved by financiers, by insurance companies, by producers, by a lot of people, and they want to be free of risks or minimize them as much as possible. So please both speak a little bit about that.
Yes, thank you, Luis. I will start mentioning that there is a significant increase of claims in Mexico dealing with the unauthorized use of image and likeness of persons appearing or which are characterized in series and movies. It is a significant phenomenon that we are dealing right now in Mexico, and this reflects the importance of analyzing if it is necessary to obtain the corresponding releases and authorizations to use or exploit the likeness of a person in connection with these audiovisual productions. And it is true, the general rule is that it becomes necessary to obtain this authorization. This is the general rule that apply in all the cases. However, there are some exceptions and limitations provided by law that allows the use or exploitation of the likeness of a person without any authorization. There are local and federal laws in Mexico dealing with this type of issues. However, the common point regarding this local and federal laws is that it is important to establish a balance between freedom of expression and these personal rights derived from the likeness or the name of a person. So we have noted in practice that in these claims and these litigations that have been filed and that are currently now being solved by either the Mexican Patent and Trademark Office or federal or local courts in Mexico, a valid exception in connection with these type of uses is opposed as a defense freedom of speech and freedom of expression. Of course, there is this collision of rights between these personal rights regarding the name and the likeness of persons, and on the other side, freedom of expression. Therefore, it is always necessary to conduct a weighting or ponderation of rights, stating that proportionality is the main topic or aspect to take into account. If it is proportional to use the likeness of a person in connection with freedom of speech or not. And of course, if we are in the presence of a docuseries or in the presence of fictional dramas inspiring real facts or stories of public interest, it will be easier to oppose as a defense freedom of speech. Mauricio, from the clearance side, I think that you can explain us a little bit more these particularities regarding this type of analysis which is conducted in the clearance regarding this weighting of rights between the likeness and freedom of expression.
Of course, thank you. It's a must in every single audiovisual project to have a clearance procedure. Doesn't matter if it is a project that it's going to be loosely based, inspired, or even entirely fictional. Documentaries, no matter what, all projects need to have a clearance procedure. This clearance procedure might involve avoiding infringement of third-party rights, copyrights, image rights, personality rights, privacy rights, and some other laws that might be applicable, alcohol, publicity regulations, health issues, and some others. The clearance work from a lawyer in the entertainment practice needs to consider several laws and several practices that.
What about data privacy, Mauricio? Because I think that we are starting to see the first cases in Mexico dealing with data privacy issues related to audiovisual productions.
Of course, well, we have a conflict that, for instance, we have several laws that states different kind of interpretations, or we might give them different kind of interpretations for the protection of privacy. Some have exceptions that might be applicable, although a different law will challenge into that exception. In particular, we are talking about the copyright law that has some exceptions to this, to the use of the likeness and the use of portraits of people or individuals that might be portrayed in a project. We have all these legal exceptions that are tied to the freedom of speech, and as a human right, the possibility of making audiovisual products or any kind of cultural or any kind of artistic works that might be done and that might use the likeness of someone else, the likeness of any individual that may be portrayed, and the legal exceptions to do that. The first one is the freedom of speech, obviously, but that needs to be really worked since the beginning and the development of a work. For instance, in the audiovisual production, when we are on when the production company is developing the audiovisual production itself, it starts with a writing process. That writing process needs to be procured by legal counsel that makes a risk assessment during the writing process of these kind of projects. The risk assessment needs to consider, obviously, privacy, likeness, copyrights from third parties, and some other applicable laws. And there are some projects, obviously, depending on the project itself and the gender itself, we might have some broader licenses to not infringe third-party rights, but for use the likeness of third parties without having the need to consider an authorization to obtaining any kind of authorization from these third parties. In some cases, it's practically impossible to obtain these authorizations. Nonetheless, we need to find a legal way to still be able to protect creativity on the projects. That's on a personal, and I think on this law firm, we are really focused on trying to protect always creativity and finding legal creative solutions to these issues.
That was going to be my question. How, if you're a lawyer, lawyers are famous for killing ideas. How to be a lawyer that is really good in waiving, giving a balance between protecting and allowing that creators create.
Yes, of course. Obviously, our duty as lawyers to our clients is to inform them and to make the risk assessment and all the evaluations that need to be done over a project to inform possible risks, possible defenses, and there are different cases that a project might be of high risk. Nonetheless, we might have good defenses from the beginning, and it's very important to be a part of this creating process with them to give our insights that might be used in the future for a legal defense in a litigation. We start to build the defense of a case since the writing process. This is very important, and obviously we don't like that the law changes creation, but we'll need to apply the law in a creative way to allow creation to happen.
And make the writers become sensible that they have to be responsible of what they write. No,
of course, and clients need to have the information in order to take decisions. We don't take decisions from for them. We make them aware of any risk that might happen, and we give them all the information they need in order to take a decision if they're gonna go for a project of high risk or if there's no need to. There are some projects that there's no need to have a risk, so things might just get changed. But there are some projects that, in order to be expressed as they were thought by the authors and the way they want to express their creativity, their works, they need to accept the risks, and we are there for them in order to evaluate to assess the risk and to start constructing the legal defenses of what might end up being a litigation in the future.
Again, data privacy laws are overcoming in some way the well, what it exists in connection with copyright exceptions and the principles of freedom of speech. What can we think about it, or how can we balance that too?
I think that the answer would be proportionality. Proportionality. If it is justified to use the likeness of a person, including her name or the likeness per se, if it is justified or not, depending on the context and the message that you would like to express. Because it is true that data privacy law and copyright law have a completely different purpose and completely different nature, and they might collide. Thus, applying an exception specifically related to copyright might not be helpful in connection with data privacy issue. So proportionality, from my point of view, would be the answer.
So privacy, data privacy laws and copyright law, and in particular copyright exception laws, are on the same level and need to be weighed and pondered every time there's a dispute about.
Yes,
right?
Copyright should be considered as a human right. There are several international treaties recognizing copyright as a human right. And actually, this is the treatment that the Supreme Court of Justice in Mexico and other authorities have adopted. And they have stated that copyright must be considered as a human right and must be weighed or pondered as such if there is a collision with other human rights.
I think we have to answer some questions because I think that time is coming up, and we have received one. I think you need to explain a little bit more, Jaime, whether in Mexico there's a system of notice and takedowns under the law. We know you have already talked about this and the challenges it has received by the Human Rights Commission. But please briefly talk about that a little bit more. It's a question that we have received.
Yes, I think the question, Luis, is more related to the possibility of requesting blocking actions before the authorities in charge of dealing with copyright litigation in Mexico. And the answer is yes. Yes, it is possible to request the implementation of preliminary injunctions consisting in the blocking of a website or a platform or any other media over the internet. But as I was explaining, derived from this so-called Alestra case, it becomes necessary that the authorities ordering these injunctions analyze or weigh the possible collision between copyright and access to information and freedom of speech. And in that sense, these blocking actions in Mexico are available, but they must not be total. They must be partial and restricted only to the infringing material that it is being displayed on the internet. And talking a little bit more about the notice and take down procedure, well, there are recognized the specific safe harbors for hosting, linking, and caching, which are the same that are provided particularly by the DMCA and also by the European directives. And I must say that we have not use the notice and takedown procedure in Mexico because there are no so much Mexican legal entities, intermediaries, or platforms displaying contents or material which can violate copyright. In our practice, all the takedowns that we have requested have been done under the basis of the DMCA or European directives because of the fact that the platforms are based either in the US or in Europe.
And what about the Mexican platforms? They are also important. Claro Video.
They are important, yes, of course. But I am pointing out that in practice, we have not used the notice and takedown procedure regulated by the Mexican copyright law. And it is also—
And is it because it's under challenge?
It's under challenge, and we don't know if it affects, if the Supreme Court will invalidate these amendments to the copyright law. So we will need to see how the court address these issues, and we'll see. We'll see.
Okay. Here's Robin asks, what are the top three differences between Mexican and US practice in handling copyright issues, either protections or clearance? I think it goes for you, Mau.
Yeah, just to point out three basics. Under Mexican law, moral rights cannot be waived. So that's an important part, and that's commonly asked on US agreements. Other important thing is the registration that has already been explained, the principle of absence of formality. Nonetheless, it's also used in agreements under Mexican law. And maybe a third one is the validity time and duration of the agreements. Under US law, it's very common to have agreements that are in perpetuity. Under Mexican law, that might be challenged, that might be invalid, that might be null, because under Mexican law, we need to define a term of the agreements. And there are
based on the copyright term.
Exactly. You know? Based on copyright terms,
although it should be the same in the United States as well, but industry likes to use concepts like perpetuity and universality and all that. No? So, yeah. Sorry for interrupting.
Because if perpetuity even exists, but yeah, the perpetuity thing and the term of an agreement that involves transmission of copyrights under Mexican law is that the law states that the maximum for an agreement of this kind is 15 years. Nonetheless, there's a section of the law that allows this term to be increased if the investment made or the work itself deserves to have a different term. So it's nothing complicated, but it needs to have a correct wording. If not, it would be invalid.
Okay. Super. Please go ahead.
I think that there is also another question regarding website blocking, in the sense that what about those websites which are overwhelmingly infringing? And in order to answer this question, I would say that according to the rules settled by the Supreme Court of Justice, stating that the totality or majority of the content of the website must be infringing in order to the injunction order to be implemented. I will say that if the majority of the website and not the totality is infringing, the injunction order should allow the total blocking of the corresponding infringing website. And I believe that we do not have any cases in Mexico on which we have argued or claimed that the majority of the website displays infringing content. But from my perspective, that would be the solution. The term totality should not be interpreted from a grammatical standpoint. It should be interpreted precisely attending or as a synonym of majority. Otherwise, it would be impossible to have an efficient way to combat piracy of websites related to this type of action related to copyright.
Okay. We would ask the organizer if we have used all the time now, or time is over, or if we can we continue answering questions or making comments about
Hi,
the issue.
Luis.
Please let us
Thank you very
know.
much for asking. I think we have time for one more question. We still have a good number of people with us, so please do go ahead and ask the final question.
Regarding
We have one, but I don't know if we have answered it already. But let's go ahead. Alejandro asked whether copyright economic rights of a work can be transferred indefinitely. You have talked about that, Mau, but I think you need to stress out a little bit more.
Yeah, they can. We need to define the term of the transfer. Nonetheless, you can work on a wording that implies that this transfer of rights, it's going to be for the term of protection of the work itself. So practically yes, but formally no.
Well, indefinitely, I think is a word that would require some sort of interpretation, no? Because indefinite, what it means indefinitely. Perpetuality, no. Indefinitely, whether you can not provide a given term to finish a contract implying the use of copyrighted work, probably yes. No, I think it's what you stating. Is that right? Am I right?
There's also a disposition on the copyright law that it's undefined. It's considered to be a 5-year term.
And how to overcome that? Are we limited in every copyright assignment contract to a term of 5 years?
If it's
copyright assignments,
if it's not
expired 5 years after being signed, that's would be my question to you.
Oh, if it's not well drafted and it's unclear, then for instance, the copyright authority might consider to give the term just 5 years according to the law. Nevertheless, this might be, if you only mention that it's going to be for the maximum time that the Mexican copyright law allows, it's going to be 15 years. So what needs to be done is to have a really good drafted clause about the term that states that it's going to be for the term of protection of the copyrighted work, justifying that the investment required to produce it or to the exploitation of the work justifies this increase of the maximum allowed by law.
And for example, let's say the production of a movie
that
falls into that.
Perfect example of an investment that needs to have a transfer of rights for more than 15 years.
Super. I think we have covered that question exhaustively. Do you want that we continue answering questions, organizers, or let us know?
I think looking at the time, unfortunately, we are going to have to end it there. But I will say thank you very much to our panel for their insights today. Your expertise is truly appreciated. So thank you very much for sharing that with us and being with us today. Also, thank you, of course, to our audience for being with us and sending in those brilliant questions. So Luis, Jamie, Riccio, I'll let you say goodbye to the audience and we will end it there for today.
Thank you, Dan.
Thank you very much.
Thanks,
And thank you, Liz.
Goodbye.